Meeting of the House Judiciary Committee. Who's here on Senate Bill 420, the child support bill? I was saying you're here on behalf of Senator Kennedy?
Yes, I'm here. I work for the Department of Human Services.
Okay, I'm gonna probably call that up first. So you may want to just come on up now if you'd like. We have 3 bills for consideration today. I want to first acknowledge and thank Judge Sean LaGrua coming with us today of the Superior Court of Atlanta Judicial Circuit, and a resident of one of the finest cities in Atlanta area. That's Sandy Springs. So we're glad to have you with us, Judge. Always a pleasure. And although not my district, close by. We're going to take under consideration first Senate Bill 427. And if you would introduce yourself, please, sir.
Certainly, thank you. My name is Stephen Harris. I'm an Associate General Counsel with the Department of Human Services. I work directly for the Division of Child Support Services.
All right, sir.
Thank you.
Tell us on 427 what the changes are and why we're doing
I
it.
definitely will. So these proposed updates to Georgia's statutory child support guidelines are to bring Georgia in compliance with federal regulations on state-administered child support programs. On December 20th of 2016, the U.S. Department of Health and Human Services Administration for Children and Families Office of Child Support Enforcement released regulatory changes applicable to all state-administered child support programs. The regulation changes, which were titled the Flexibility, Efficiency, and Modernization in Child Support Enforcement Programs, I'll refer to this as the final rule moving forward. These regulation changes went into effect on January 20th, 2017. Now, the changes that are in this bill provide for 4 parts. First, that consideration must be given to an obligor's ability to pay the court-ordered child support amount. Then incarceration may not be treated as voluntary unemployment when setting a child support amount. The imputation of income must be based on evidence of an obligor's ability to earn and other economic factors. And a child's eligibility or enrollment in public health care is to be sufficient for required to meet the court's obligations to address health care within the child support order. If Georgia does not come into compliance with the new regulations, the state runs the risk of losing funds related to the TANF block grant.
Where do we not come in compliance?
Currently, the federal regulation requires the guidelines to include these 4 factors, and each of which are not fully implemented in the Georgia's child support guidelines at this time.
Okay, we left it general. I think.
Yes, we did.
We go back to 2006 and 7.
Mm-hmm.
At that time, we sort of left we gave the statement, I know, in the law that as far as like the failure to be employed, et cetera, allowing the court to look at the factual situation. We're now putting in specific things addressing what are to be considered or not considered relative to the earning ability of a non-custodial or custodial parent, right?
That's correct. We're putting in specifically that the court has to, when setting those orders, has to actually address the ability to pay. And for things like that voluntary unemployment, incarceration would be the same as voluntary employment. That's currently not in the guidelines, but there is case law from the Georgia Supreme Court that we'd have to supersede with this statute to come into compliance with the federal regulations. Okay. So also within this bill, there's a change of the annual maintenance fee, which the Division of Child Support Services charges to obligors. That's raising the fee from $25 to $35. This is due to a change that the U.S. Congress made in February of this year, requiring agencies to increase that fee.
Section 2.2.
That is Section 2. So in addition, since the time that the Senate passed this bill, there is a substitute before you today. It addresses some concerns that were presented about this bill from the Georgia Child Support Commission. So the substitute removes a paragraph regarding nonspecific deviations that the commission felt was unnecessary. We determined that the bill would still bring us into compliance with the final rule for that language to be removed. As well as yesterday in the Fleming subcommittee, a question was raised about the word parent on line 87, and it is in your substitute bill, that word parent has been changed to non-custodial parent, which is a more accurate description of the way deviations work, as this sentence is addressing.
All right, thank you. Questions of the presenter, Ms. Oliver?
This bill affects all litigants in the court where the child support guidelines are imposed, not just the state child support work. I'm
That is
correct
correct.
about that. I don't remember the details of Representative Beskin's bill on the Child Support Commission this year. I don't remember those. But did they not consider raising the $25 to $35? Was that in your bill?
Don't
Or was that in Ms. Beskin's bill?
You know what, I should pull that bill up and look. I was thinking of one other way in which these bills conflict.
Yeah.
I don't, I should remember the bill. Let me pull that one up. But
I'm
that bill is currently up for consideration by Senate Rule.
I'm just trying to figure out the conflicts, and let me draw your attention specifically on page 2 to line 34, line 36. Judges have been allowed to impute income based on minimum wage 40 hours a week.
Correct.
It seems to me you're taking that out, and I'm trying to figure out
That is I'm sorry.
what's the policy reason for doing that?
That is a direct response to the final rules, which require the state guidelines to impute income
Okay.
not based on a certain set amount, but to be based on economic, employment history, things like that.
What you're
as
doing is
stated
that
in
you're
this.
requiring a whole nother hour of evidence and testimony about a man or woman who doesn't work, about his or her particular circumstances, other than the judge having the freedom of saying. I can't
quite right.
figure out whether that's a good. I'm just thinking aloud to myself. Is that make it harder on the courts, or is it more fair to add that extra hour of testimony for the parent, non-custodial parent who's not working?
Yeah, it could, and keep in mind that hopefully parties, and certainly the department, will have these kind of issues settled before we get to court. We'll have that imputed amount of income in the child support worksheets that we prepare prior to court. So if it's a disputed hearing, it's quite possible that it could increase the court's time. However, it does give the judge more flexibility. I mean, I know in certain cases where judges feel that full-time minimum wage work at 40 hours a week just isn't possible in their area. So some judges are already imputing like 30 hours a week. and
One
things
more
like that.
question, if I may, Mr.
Sure.
Chair. Lines 41 to 43 says the incarcerated parent's pre-incarceration income may not be imputed, but shall be based on actual income and assets available to each incarcerated parent. I'm trying to think of where that would really apply to a non-custodial parent coming out of prison. Where do you get the evidence of why couldn't you use the previous income? That's what's confusing to me. But
Right. So this is again
where did it
part
come
of
from?
this is part of the protections that the incarceration cannot be treated as voluntary unemployment. And so if that incarceration was not voluntary unemployment, then when the person who is leaving incarceration is then entitled for the judge to consider their current wages and ability to earn rather than their pre-incarceration wages and ability to earn. So we were making sure that was clear here in those lines.
It's another evidentiary barrier of some kind.
Yeah, that's what I was saying earlier. We left it specifically on this general basis, not to try and go into all the things had to be reviewed or considered, but let the court guide as to what they felt was important and relevant in the question about imputed income.
If the guy was employed 5 years ago prior to his incarceration, and he's coming out of prison now and has no job, and that job entity went away, I'm trying to figure out how you prove whatever. It's just a little bit confusing.
Well, I'll be looking at current ability to be employed, which certainly when you have a criminal record, that's going to be a challenge, you might say.
That's correct. And we do have employment programs to help people who are coming out when there's a Division
Some.
of Child Support Service case involved. There's also the Georgia Department of Labor provides labor statistics to help to determine a level to impute income as well. So it's a tool that's available to the public given the person's occupation or intended occupation.
Why don't you tell us, if Georgia revolted and didn't follow the federal guidelines, what would be the outcome?
It would definitely be sanctions levied against the TANF block grant, which is, I believe, $250 million. They could sanction or completely remove that block grant from the state.
Always the long handle. Any further questions of the presenter? Is there anyone else in the audience who wishes to address the committee on Senate Bill 427? We're working from LC 298057S. We will close off further public comment. The bill is now in the breast of the committee, and we'll have committee discussion. My first question, Mr. Fleming, is if you would tell us your subcommittee's review of Senate Bill 427.
Do pass.
All right. We have a motion. Do we have a motion to pass?
Second.
Do we have a motion?
Do pass.
You make a motion to
Yes.
pass. All right. Second the motion. Discussion on the motion. This will be as to a committee substitute. The motion is due pass. Do we have any amendments to be proposed? No amendments. The main question is a motion due pass Senate Bill 427, a committee substitute, LC 298057S. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Who will be the sponsor in the House? Would you like Ms. Beskin to present this? Who do you want? Who is? Dempsey. All right. Thank you. Yes, sir. Yes, yes. All right, we had two measures on Mr. Liggins. Senator Liggins, you want to come forward, please, sir? And how do you want to take these? We got Senate Bill 338. You want to take that one up first?
Yes, sir. Why don't we take that one
All right.
up first?
This is a bill that deals with a issue. Let me give a little background before we start your testimony, but the question here is, under what basis is the legislature as a body able to question and perhaps even prevent a rule coming into effect that we find to be disfavorable or not in compliance with what we had as either policy or law implemented by the state? And so the question was how we were doing it earlier, at this time, I should say not earlier, but at this time, is it constitutional or not? And we've come to sort of the understanding it may not be constitutional, so we've tried to look at what has been done by another upper legislative group, that was Congress, in looking at the same thing and implementing rules, and how they have questioned this, and how the Supreme Court has reviewed those policies and statutes and determined what is to be a constitutional format for making a challenge to the either implementation or amendment of a rule. And we put this into a document that has taken the current rules we have in Georgia law and tried to make the appropriate changes. So with that little bit of background, I'll turn it over to Senator Liggins.
Thank you, Mr. Chairman, and I can give just a little example of how this worked with us last year, if you would
Yes,
like
sir.
for me to.
Please do.
Last year we passed a bill that attempted to create a statewide registry for filing Department of Revenue liens, and based on the language of the statute, the Department of Revenue came out with some regulations, and I think that rightfully their interpretation, I mean, there was justification for it, but it would have required a person that wanted to record a deed in the deed records to first obtain a certificate of clearance, that is, get permission from the department before they could record the deed. Well, that had the potential of completely upsetting our recording statute and the priority of recordings. We're a race notice state, which means that whoever gets to the courthouse first with their deed without notice of a superior claim or lien or deed wins. And the delays that could have caused in getting that certificate would have really upset that, and the legislature did not consider that possibility in passing the legislation. And it also would have given the department a super lien status, which we also did not consider when passing that legislation. So we looked at the existing statute that would have allowed us to have suspended the implementation of the rule. And it was a very cumbersome process. It required us to have a vote of 2/3 of the members of the committees that heard the bill, in this case the Ways and Means Committee in the House and the Finance Committee in the Senate. But it's 2/3 of those who were in office on January the 10th. And trying to get members to come to a meeting in November during the Thanksgiving holidays is next to impossible. But then the Senate had lost some members who had resigned their seats in order to run for higher office. And we were right at that line. We had to have everyone there in order to meet the requirements of the statute. And so we filed the bill to make the changes to it and to reduce that to a majority. And then the chairman here in this committee began looking at it, and they've come up with a substitute bill that brings this into compliance, probably with constitutional law. And as I understand the bill and as written now, and I don't know, Mr. Chairman, if you want me to go through it as best I can, or if
You
you
know,
all want
I'll
to.
be glad to help you out on this, because we did have a lot of discussion, Jordan Reed and I, and working on this and trying to look at the Supreme Court decisions and what we currently had in the law and how to form a bill procedurally that would meet those constitutional tests. And so what we've come up with is, and I'll try and just give sort of an oversight to it, the bill provides for there being a publishing on the website of an agency a proposed change in rules, either implementation of a new rule, amendment of a rule, or deletion of a rule. So that has to be done, and it has to be done 60 days prior to the date of the hearing. And there will be a potential hearing for 30 days prior after the publishing of the notice for the purpose of allowing public input to that proposed rule change. Those dates and times are to be set out. The agency then would have the ability to adopt the rule, and that rule would be considered adopted by, say, whatever body is charged with that responsibility. But that doesn't necessarily mean the rule becomes implemented, because as one of the major changes we made here is this. If a agency adopts a rule, say on July the 1st of this year, that rule will not have impact and be considered as enforceable until March 15th of the following year. In the meantime, they will present that information to the Secretary of State, follow the Secretary of State, as well as to Legislative Council for the General Assembly. So that rule change comes into our body through the Legislative Council's office. Legislative Council office would then notify the appropriate committees, as well as the President of the Senate and the Speaker of the House. And if we had, let's say, something that dealt with, I'll give the example, the Real Estate Commission. If they adopted a rule, that would come to this committee for its review. If we found, for some reason, within the committee, reasons to concern or question this as a potential rule, when we come in, let me stop right here. All rules for consideration have to be in by December 15th for that year. So you file the rule. If it's adopted in July, whenever, you have up until December the 15th to have them filed. Then, after that date, on the session starting in January, the House and Senate would have the opportunity to consider that rule and make a determination. If we've got objection to it, we would both be able to adopt a resolution. And that resolution would only be adopted, I think it was 2/3 or a majority. I forgot what we did.
It's a majority of
It is a majority. So it is just a majority. If we had, for some reason, to disfavor that rule, we would do a joint resolution adopted by both the House and the Senate objecting to the rule.
Yes.
Or we could also be able to adopt a resolution allowing for the immediate implementation of that rule. Now let me stop here and say, this is not to look at every potential rule, because there could be times there's a rule that needs to be implemented, what we call public safety or health reasons.
Right.
And if that's the case, we have another procedure. That procedure would call for the rule to be adopted by the agency and submitted to the governor for the governor's signature and approval on the basis that it is an emergency rule. But even those emergency rules would be also under consideration come time for the legislature to meet. So the point is, we have that window of opportunity while the legislature is in general session from early January up to that March 15th date. If we don't do anything as to that rule, it will automatically become effective on March 15th. Now, if we have an objection to it by joint resolution, that would be submitted to the governor for his consideration, and he can either approve our position of rejection or he can veto it. If it is vetoed, then it'd be handled just like a regular bill would be. It would require a 2/3 supermajority of both bodies to overcome that veto. Now that's sort of a window view of what we've enacted here as far as the language in the bill. Have we missed anything of importance?
It needs to be submitted by December 1st, not 15th.
It's the first, excuse me, okay, I'm mistaken, it's December 1st they have to submit the information as a proposed rule change, and it would only be effective by March 15th. So the idea is to just be sure that the legislature has a enforceable constitutional procedure in place to look at rules and, if necessary, make a challenge to them.
Yes, sir. I think that's correct. You stated it well, Mr. Chairman.
Do we have anyone else that wants to address the committee on Senate Bill 338? If not, we will close off further public input. The bill is now on the breast of the committee. The chair will entertain a motion. We have a motion to pass, and a second to that motion. Do we have discussion on the motion? There be no discussion. Are there any proposed amendments to the motion? No amendments. We'll go to the main question, which is a committee pass of Senate Bill 338 as a committee substitute with LC 411556S number. All in favor signify by saying aye. Opposed, like sign. That motion carries.
Thank you, Mr.
Good
Chairman.
legislation.
Thank you, Mr. Chairman.
All right. Now we're on to Senate Bill 339.
Thank you, Mr.
Senator
Chairman.
Liggins.
Yes, sir. As we all know, one of the fundamental cornerstones of our liberties is the freedom of speech, and unfortunately across the country we've seen instances where policies and practices on some of our campuses have been quelching or free speech or shutting it down, hindering it, and this has been occurring in various ways. We've seen this done through free speech zones. We've seen students come up and actually disrupt planned events where speakers are there invited to speak, but because of the yelling and the disruption, the speaker is not able to talk and present his views, and obviously students there who are there to listen were not able to hear the views. And so the purpose of the university, which is the exchange of views, being challenged and debate and learning, and is being thwarted. And we've also seen instances where speeches were canceled by some administrators for various reasons. And so the protections that are guaranteed to our students under the Constitution have been lost or relaxed. And certainly we've not been immune to that in our state, and not to say anything bad about our administrators and our universities, but for a period of time now, there's been some incidences that we think really need to be addressed by the legislature and by this legislation. And we know that in 2004, 2005, there was a suit at Georgia Tech where a student's rights were infringed upon. It cost the state over $200,000. There was a suit in 2014 against the University, which was ultimately of Georgia, which was dismissed and settled. There have been shout downs at the University of Georgia 2016, 2017, and now apparently, I've just learned today, since it's happened again since this bill was filed, 2017, a couple of our universities earned rebuke from the Foundation for Individual Rights and Education for unconstitutional free speech zones. And of course, we all know that Kennesaw State University has received a couple of lawsuits now for violation of the First Amendment rights of students on that campus. And so we worked with the chairman, and certainly there have been changes and revisions to the bill, but that is the purpose and intent of SB 39, and hopefully this will help reassert those protections that our students need and deserve.
Thank you, Senator. Just again to chime in for a little bit, the bill that came from the Senate, we've taken that bill and have tried to, I say, pattern it into what we really look at as a normal way of having legislation and the wording of legislation for our code, especially the civil code. So that's why we made the changes that we did. And there are some questions of members on the panel here that we would ask for you to indulge. Mr. Bruce?
I hear what you're saying is the intent of the bill, but the flip side of this is that the people that are protesting also have a right to protest. And so it seems like that we're picking sides on this and saying that the person that you wanted to hear from, or that those folks wanted to hear from, wasn't speaking as loud, so to speak, as the other folks. But everybody was exercising their right to speak. And I guess, you know, what's troubling for me is even here in the General Assembly, you know, I don't know how it is on the Senate side, but on the House side, when we get these bills and we're about to vote on them, they come to us in 3 different forms. Some say that we can debate them. Some says we can't debate them at all, and others says that we can debate them a little bit. So even here in the General Assembly, our right to speak out is somewhat abated. And so I just find it a little bit difficult to believe that this bill is actually about freedom of speech. It's about limiting the speech and deciding who gets to speak.
Let me call your attention to line 37, Mr. Bruce. That was a concern we had too. We hope we've addressed it by what we said to assure that any student or his or her invitee lawfully present on campus of these institutions may peacefully protest or demonstrate, provides that students or invitees comply with the applicable institution content neutral time, place, and minor restrictions. And so what we're looking at there is someone who is wanting to protest what another person may be saying on campus or activity on campus can do so, not necessarily having to be a recognized organization for a protest. So the idea is to be sure that it is left open for those who disagree to be disagreeable as long as they do so in a proper manner, whether or not cause the damage to property or interfering with other expected activities on campus.
And I agree that we should not be destroying property in the process.
Yes.
We should not be causing physical harm
Right.
to anyone. But I do know that speech can be limited by the rules too. And
Well, that's why
that's what I guess I'm objecting to, is that you can create rules that limit a person's ability to speak. We do it here in the House every day. You say that there's free speech, but it's not really free speech if you're setting rules that limit that free speech. And that's all I'm saying.
Yes, sir. Thank you. I think the next was Ms. Oliver.
I think that section 2348.1, lines 50 through 62, requires the regents to do some specific things and to give us more information. But just on the surface here, I can't figure out what the rest of the bill accomplishes as a matter of law that is not subject to anyone who feels they've been infringed upon on whatever side from going to court. I don't see how any of the parts 1 through 49 and 63 through 69 change the law
Well,
in
this-
any way.
You know, the problem is, and certainly if we want to strengthen this some, we're open to suggestions. But part of the problem is that, you know, for a period of time now, it seems like you're having to go to court, and a student shouldn't have to go to court. And the in that particular suit against Georgia Tech, it was pretty strong, and she faced a lot of she had to have security at one time to help her to go to class. I mean, it was just a very
I
difficult,
don't see how your
challenging
law
thing.
changes or makes it easier for either the student or the regents to move through the necessary actions that any individual wants to take to exercise free speech. I had a little experience with free speech myself this week in the courts, and nothing in this bill changes the fundamental right of free speech. It does impose additional workload.
Well, it does, and it requires the Board of Regents to publish a report, and
Yeah, I'm
certainly
for that.
I
I'd
mean,
be for that
that's
section.
that's a good thing.
I'm okay with that
And-
section. I just
and it-
think the rest of the bill only subjects the person seeking free speech and the response of the regents to more problems and not solutions. I'm happy to support your
You know,
50 line
right.
list.
Well, I can point something out to you. Lines 45 through 49. We have instances where students are shouting down planned speeches so that the speakers that come can't be heard by the students that want to hear that speech. And in a sense, it's just like being in a classroom. It's just instead of a professor, you have an invited speaker coming. And these disruptions have continued. 45 through 49 direct the regents to establish a range of disciplinary sanctions for those who are disrupting those speeches. And so if you do that and you're disciplined, then that lets you know that there's a consequence for disrupting that speech, just as there should be a consequence for disrupting a professor in the classroom. So, I mean, I think that it does do some things that would help bring some order and that would promote the exchange of ideas on our campuses.
Yesterday we had an incident where because the room was overflowing outside the number of people that were allowed in the room, certain participants were asked to leave. I thought all that was appropriate. That's under existing law. The Regents doesn't have to pass a rule that says you can't scream and shout and disrupt a classroom, do they?
Well, they may need one for invited speakers because it's happening. And I believe there are people that are here today that will talk about it, that have personal experience with it. And I'm looking forward to hearing from it because I haven't heard from what they're going to say. So, I mean, I do think this is needed. I think that it sends a message that the legislature is very concerned about this, that we want to promote an open environment on our universities where ideas can be expressed and students can hear and learn and be challenged and challenge those ideas as well. So,
Thank you. Mr. Dreyer.
Thank you, Mr. Chairman. I've done a little First Amendment work, and I'm seeing a lot of information in here that's taken from Supreme Court interpretation of the First Amendment, right?
right,
Content neutral, time, place, and manner restrictions.
right.
So a lot of what this seems to do is to take the First Amendment and Supreme Court jurisprudence related to the First Amendment and put it in this law.
Right.
So there are these protections, and I guess you're arguing that you don't necessarily think students should have to go to court to protect their First Amendment rights?
Well, no, I'm just saying that it shouldn't be that way where you have schools, for example, one of the cases in Kennesaw University right now, the allegation is that discrimination was made based on the content of the speech. That should be so obvious that it shouldn't happen, but yet it did. And I think it's appropriate for the legislature to address that so that it does not continue. And our students shouldn't be put into that position where where they're going to an institution to learn and to be challenged, and all of a sudden your speech is hampered because of the content of that speech, when other groups who have equal access to that area are given priority because of the content of their speech. The university should not be picking winners and losers on this, and that's what's happening.
So, I certainly agree wholeheartedly with that. My experience has not been universities picking winners and losers. In fact, I will say this though, for court, when you go to court to assert a First Amendment rights, I have personally, on behalf of the client, been awarded attorney's fees from the state of Georgia for trying to limit speech at this Capitol. And that was several years ago. So the protection of the First Amendment, not only are they available to all students, but there are a large number of attorneys and interest groups that will represent those students and get paid attorney's fees if there's
Sure.
an infringement. So I too, I'm not sure how necessary this is.
Okay. All right.
Thank you. I guess who's next? Mr. Fleming.
Representative Dreyer, I think the point of the bill is that they don't have to go to court. We want you to get attorney's fees, and me too, but we don't want you to get them against the state because they infringed upon someone's right to give a speech. So I think the purpose of the bill is to stop that from having to happen. And quite often we pass measures to discourage lawsuits or to hope that they're not
Yep.
needed because they're taken care of initially when the actions are going on. And that's why I support the senator's bill. The other part of this is what Representative Bruce, I believe, mentioned, and that was sometimes the rules don't allow you to talk as much as you want to. That's called time, place, and manner restrictions, I believe, Senator Ligon. And that's always there, and including in this bill. There's always time, places, and manner. However, though, Representative Bruce, when you do obtain the will of the House to speak, it is not my right to shout you down so that you can't speak to the rest of the House. And once again, Senator Ligon, correct me if I'm wrong, I think that is the purpose of your bill. Once one obtains the right to give up and give a speech because you've been invited, you shouldn't be shouted down where you can't be heard. Am I wrong?
That's you're exactly right. And when you're shouted down, we're robbing students who came to listen of that opportunity to hear what's being said, and so they may not disagree with it, and there sure will come a time when they could express that agreement in an orderly fashion, and when they have the opportunity to do so, they should not be shouted down. They should be heard as well.
Thank you.
Mr. Welch. Mr. Welch waves. Mr. Bruce, is that yours or? No, it's Ms. Beskin. Excuse me.
Thank you, Mr. Chairman. And Senator, thank you for this bill. I have a question in the first section, Part 1D, line 17, 18, talking about the Board of Regents shall adopt policies. I have a question about A2. To paraphrase it, the Board of Regents shall adopt regulations to foster the discovery and dissemination of knowledge by means of debate of different ideological positions. What are your thoughts on that? I mean, I thought that was what college was all about. I think this is, in my mind, this is the essence of what institutions of higher learning do, is all of this. So why do we need to tell institutions of higher learning to do that? And specifically your question about instructing them to have a policy where they're making sure they instruct people about different ideological positions.
Well, when you allow shout downs to occur, when you have speakers disinvited because of the content of their speech, when you allow disruptions to planned speaking events, then you're not allowing the dissemination of knowledge. You're not allowing teaching, discussion, debate of different ideological positions when that speech is hampered. And so, yes, you're right. It's what universities do. But because this has happened, we think that those positions should be reinforced to encourage that on our campuses.
Now, one of the things that might bring to your attention too is the fact that we have in here the expectation that something be done by the Board of Regents where there is found to be a disobedience of this right of free speech on campus, where a administration of campus, personnel of campus may be seeking and attempting to try and quash abilities of someone to give that free speech. So we say under line 45, section B, subject to notice, hearing, and due process requirements, the Board of Regents shall establish a range of disciplinary sanctions for anyone under the jurisdiction of the state institutions of higher learning who is found by his or her conduct to have interfered with the Board of Regents regulations and policies relevant to free speech expression on the campus of each institution. And let me add here, we've had handed out what is a one sheet. This is all really we have right now in the Board of Regents, but it's a good statement.
Yes, sir.
It's just that we wonder, is it being complied with? And now we have attached to the bill, your bill, is a letter from the Chancellor of the Board of Regents, Steve Wrigley, to the President Harmon of Kennesaw State, because there is, in fact, an item coming to their attention where there has been this failure to comply with a person's ability to speak freely on campus as they desired. I think that person we have here today to address this committee, is that right?
Well, I don't know exactly, but I want to express my thanks to the Regent for sending that letter and
Yes, sir.
and addressing that.
So I think they're getting the attention that they know there is an obligation of the Board of Regents to be sure on these state institutions. People should have the right to exchange ideas. That is for sure, as Ms. Beskin said, that is really the purpose behind having these institutions of higher learning.
Yes, sir.
Just to exchange ideas freely, whether you believe it or not. You know,
Yes,
the old saying, I may not always agree with what you say, but I'll defend to my death your right to say it.
Yes, sir.
Very true.
That's right.
Thank you. Any other questions of Senator Liggins? If not, I'm going to have a number of people. I'm going to call up Victor Peters. Victor Peters, if you're present. Please come forward and give us your name and who you represent.
Yeah, hello, my name is Victor Peters, and I'm a student at Kennesaw State University and a leader of a campus libertarian organization. Thank you for allowing me to speak.
Yes, sir.
Well,
tell us your story.
Yeah, well, so, you know, as a leader, I've seen a lot of things. As Americans, it is essential that we aim to foster an environment where speech is expressed freely and those who wish to speak will get to do so without having to worry about facing bias from public authorities. I think I've seen a lot of instances where campus organizations have been discriminated against. And one of the problems I see on campuses is that we have restrictions such as free speech zones that prevent people that aren't members of registered student organizations from speaking freely. So if you don't have this status, you're prevented from speaking where you like on campus. You have to speak in a small piece of the campus, and I think that's pretty.
But are you here as a result of something happened to you? Are you part of the concern being raised by the chancellor in the letter to the president of Kennesaw, or do you know?
I'm here as a student to speak about the things I've seen and the policy that we have.
All right.
I'm in support of SB 339, and one thing that I have noticed, however, is that the revisions you've made to it don't go far enough in protecting students' First Amendment rights. For instance, in line 34, the time, manner, and place restrictions should be written much more narrowly in terms of what is considered an institutional interest. I really believe free speech zones to be replaced, and this bill should be amended to make that a reality. Thank you.
All right. Thank you, Mr. Peters. We appreciate you. Anyone have a question, Mr. Peters? If not, we'll start. Next person is Rabbi Russ. Is it Schucker? Schultz, excuse me. I apologize. Schultz. I was putting an R before S. Thank you. Happy to have you with us today, and if you would give us your name and who you represent.
Absolutely. Hi, everyone. My name is Rabbi Russ Schultz. I'm the Executive Director of Hills of Georgia, and our organization represents the 6,000 Jewish students in colleges throughout the state of Georgia. I'm here to tell of just an incident that took place, and to help, which I think will help be edifying to the situation. At the University of Georgia, we regularly welcome speakers from all walks of life, and just an incident that just happened within the last month, namely on February 26th, we welcome 5 minorities from the state of Israel, namely a Muslim, a Christian, a Bedouin, and another Bedouin. And what we did was that we just had them tell their tale about how they experienced life there. Not for the first time, but we had another group there, namely the Students for Justice in Palestine, come and specifically in an organized way disrupt the program. We have a very strong policy that in any one of our programs, following the university's freedom of expression rules and code of conduct, that we always take questions when if there even is an interruption, we stop. We ask anyone if they would like to ask questions. We always make sure to have police presence at any of these type of programs, which I'll be honest is an embarrassment for us that we even feel the necessity to have it, but we always do make sure to have a police presence. And it's become a somewhat regular thing that on an annual basis at least, there'll be at least one of our programs where there'll be a shout down that we are unable to have our speakers that are usually brought in either nationally or internationally to give their perspective. Usually this lasts somewhere between 10 to 15 minutes. Sometimes students will leave because they feel either scared or they feel harassed or they feel that this is not an environment that they want to be part of, so they are not able to even hear the speakers that they would like to hear. And then after 15, 20 minutes, because of the police presence, there's usually things will quiet down, and then the group will usually one by one scream leaving out, making sure that they know what's happening. Sometimes they'll throw pictures of dead babies all over the room as they walk out of the room. And this is something that is definitely not endemic of all the colleges in the state, but something that we regularly experience at the University of Georgia. And it's definitely something that we have on multiple occasions appealed to the university's code of conduct, appealed to the university's freedom of expression. We definitely put in a complaint subsequent to the February 26th incident. We're still waiting for it to be resolved. There's supposed to be an investigation according to university policy, but I do understand that, at least from my perspective, SB 339 is meant to make things to be taken more seriously. And I think one thing that we haven't had, at least from my experience, is that a lot of times these incidences do not go in a situation where they are taken seriously, and they kind of are passed from person to person until they dissipate.
Now, let me ask you, is this occurring on the actual premises of the campus, or are you a organization that has these events in a facility off campus?
We do have a building at UGA, but this specific event was in a rented facility on the university campus in the MLC, room 150, and most of these situations are on campus property. Even though our building is on campus property at University of Georgia, is privately owned. So if we were going to have a private event, we would screen who's coming. But this event specifically was not even run by our organization. We roughly manage 10 clubs on campus, and this is one of the clubs on campus that's a university organized, recognized club.
And with this disruption, is there a procedure or something you're aware of that you have means to go to the president's office or the management of the campus and report these problems and get some redress?
So there's a policy in place at University of Georgia for complaining, namely a student has to report the complaints. And we did go through the proper protocol this year, and we're waiting. And I'll say that this is not the first time that we put forth a complaint. In years past, we've also, and it's never come to resolution. I'll speak even at Georgia Tech, where we had a specific incident of anti-Semitism. A lot of times we feel that incidences are passed from the local police to the university police to a university official, and until it finally dissipates.
Thank you. Any questions of the rabbi? I'm sorry, go ahead.
I don't know, it's not blank.
I apologize.
Thank you, Mr. Chairman and Rabbi. I really appreciate your comments here. It sounds like you welcome different opinions, but as you have hosted these events with international visitors, it sounds like it was an embarrassment to you that you were not able to have a civil discourse in your meeting. Is that your objection? That it's not the different opinion that you mind, it's the manner in which it was expressed, and it was obstructing the meeting. Is that correct?
Absolutely. We always make sure to frame the beginning of every single one of these speeches. We actually spoke with the dean's office to write a speech for framing all of these events, where we say, we are here to listen to one another. We are here to have a civil discourse, and please just follow the university code of conduct policies, to make sure all of us can be heard.
Do you think this has gotten worse over time? How many years have you been there?
I've been in the state of Georgia for 6 years,
Uh-huh.
and definitely at Georgia State and University of Georgia has gotten worse. The other campuses, I think, has been about the same.
Do you have a theory on that, or to what do you attribute that?
There's a plethora of policies that are different. I would say that a lot of times many of these groups, especially I'll just speak to this one group who's been disruptive. Students for Justice in Palestine do not have a universal policy. We actually worked really well with them at Emory because they were doing their best to defend the Palestinian people and try to make like a civil discourse. So at University of Georgia, they made a specific policy, their group, to be more on the offensive than defensive. And they try to find disruptive ways to act and try to make themselves be more public on campus. So even when we were tabling on campus, and I wasn't going to bring this up because I don't have a complaint about this, they protest in front of our table on campus no matter what we do. And we actually, I'll be honest, I personally don't have a problem with that because I think they have the right to say whatever they want as long as they are protesting in a way that's not, harassing and is approved by the university. So we really only have a problem specifically when they are breaking the university's policies and it's not taken seriously. But I do think it's getting worse over time, and I think probably demographics or statisticians would be more aligned to tell you what the reason those are happening.
Thank you.
Thank you, Rabbi. Appreciate you being here today. I don't know that I've got a sign up here of anyone with the Board of Regents, but is there anyone here I'd like to have you come up and please do, if you would. I know you spoke at the subcommittee meeting, and I think it'd be helpful for the full committee to hear from you about this. Mr. Tate, glad to see you again.
Good to see you. Chaperone.
Chaperone, right. Introduce yourselves and who you represent.
Sir. Roland Downs with the Board of Regents.
And Edward Tate with the Board of Regents, Office of Legal Affairs. So thank you for having us again.
Yes, sir.
And as you mentioned, we spoke to the subcommittee on Tuesday about Senate Bill 339. And I won't go through that testimony again, but I will outline that the Board of Regents does have a policy, which each of you have, I believe, policy 6.5. And that policy was updated and adopted last year in March and has been rolled out to all of the campuses. We've done a number of teachings and trainings through each of the campuses. Each campus has a policy that must comply with this board policy. We are constantly training, and in fact we're training today, one of 3 big training sessions at the Board of Regents on people from all walks of operations at each university system have to go through this training. And so we do have this policy in place, and as when there are infractions of a policy, we have accountability, and that's what the letter that also was attached to that from the Chancellor is referencing. So we have swift investigations should there be allegations of infractions of the policy. We take the First Amendment extremely seriously. It's very important to the university system, and accountability is also very important when there are infractions.
Thank you, Ms. Tate. Ms. Oliver.
Can you be specific with me, please, as to how 339 would change your policies other than the part that requires you to write a report back to the General Assembly?
Well, 339 does codify a number of elements of First Amendment jurisprudence already. There are some differences within 339. Specifically, there's a reference to least restrictive means, which is a legal term that's talking about traditional public forums, which all campuses are not, but they all have traditional public forum areas consistent with our policy. So that's one area that is a little different, but it's generally they're generally in line because the First Amendment controls everything, no matter what is written in law, no matter what is written in our policy. First Amendment jurisprudence is going to cut through all of that because it's from the Constitution.
I think I agree with you there. Least restrictive environment, to me, is a term that's used in the Special Education Act. So how is it used in your term about what's the least? How is this 339 change your definition? And what do you mean by least restrictive?
So least restrictive means is a standard used for a traditional public forum. A traditional public forum is Piedmont Park, for instance, close by here. There are parts of campuses that are traditional public forums, but most parts are limited public fora. So that, campus buildings and facilities that aren't a public park. But the concept is for a traditional public forum, if there's ever any restriction on a time, place, or manner restriction on expressive activity, there has to be the least restrictive means have to be the standard by which those restrictions are placed. So that's an example. Again, is if you want to do a parade in Piedmont Park, since it's a public park, it's a heightened scrutiny standard is used to determine if there can be any restrictions on what you want to do.
Mr. Bruce.
Yes, sir. Given that there are already laws in place that says you can't destroy property, you can't attack people, you can't hit them, touch them, all this kind of stuff. Given that all that's already in place in law, how does this bill, as I'm reading it, how does it, what does it change? I guess I'm not sure that I understand what it changes, other than creating additional rules and taking what is now an infraction of the college rules and making them a violation of law and criminalizing students at this point if they engage in something that they're expressing themselves. I was a student at one time too. We raised all kinds of ruckus about things. But the reality is that now what we're doing is saying the activity of expressing your freedom of speech is now criminal if it is that you are, if you're doing something that you think that you have a right to do.
Well, I'll start out by saying that the system is not supportive of this bill simply because we have this policy which we spent a lot of time to put in place. We want to see it effectively successful, but I'll also say that this bill has changed dramatically from its original form, and some of the things you're talking about are not in this version of the bill. There are earlier versions that had very strong 2 strikes and you're expelled or suspended provisions. Those are not in this bill. So the bill has moved significantly in the direction that we're more comfortable with.
And I understand that, but it still criminalizes activity.
I don't think it does that, Mr. Bruce.
No?
No, sir. It just says there'll be due process for whatever sanctions, but not, you can't do it. You can't,
okay, so it's already.
They can't put them in jail.
Okay, all right. Okay.
They can't put them in jail. No, sir. We won't be locking up anybody.
Good.
Hopefully. Any further questions? Yes, sir.
Thank you, Mr. Chairman.
Mr. Roberts.
In response to that, and not criminalizing, what kind of disciplinary sanctions are in place now for disruptive activity at a?
So there could be there's a range of sanctions that are available, and it all would depend on the severity. And again, we have due process rights already, but you could have a range of sanctions from a reprimand of some sort to suspension or expulsion. But it's in our general student conduct policy that requires certain behavior that's runs afoul of the disruptive behavior, for instance, would go before a hearing, and there could be a range of sanctions depending on each instance.
Okay.
So this language is, this is consistent with our current policy.
Okay.
Ms. Peskin.
Thank you, Mr. Chairman. And Mr. Downs?
Yes.
Mr. Tate. Yes. Mr. Tate. You mentioned that the Board of Regents objects to this bill. Is that correct?
Well, we have a policy in place that we would prefer to have that be the correct.
But we don't have anything here on our desk that tells us the basis of your objection other than, is it that you already have a policy? So, I guess my question is, what is the objection? What about this is objectionable? What is the most objectionable to the Board of Regents?
Well, the fact that we have a policy in place that we're trying to continue to implement is the main objection, and we were trying to do that. And each institution has policies that follow the Board of Regents policy. There's institution policies are much more detailed than the Board of Regents policy because each institution is different. Some are urban campuses, some are rural campuses, so they have different requirements. But specific to this bill, there are some areas that I mentioned. The least restrictive means element is a level of scrutiny that's different in certain circumstances. So that's one provision that is, the reasonable means is the more appropriate level of scrutiny in our point of view. But so that's one area of departure from the legislation and our policy.
Thank you. I might add, just as I know you don't want to raise it, but there's probably a question about whether the legislative body has the means to impose this type of statute on the Board of Regents, because the Board of Regents is by our Constitution, a separate body that we, the legislature, does not have any oversight or control to, if that's a fair way to phrase it. I think that's part of the position the Board of Regents has in this question. Is that
Well, no,
proper statement?
that position was raised by Legislative Counsel on the Senate version. I know
Okay.
that Chairman Miller read a letter from Legislative Counsel raising that issue, and this bill again has changed significantly from that version. So I don't know if Legislative Counsel has
Okay.
opined on this.
I understand. So as far as what we have now in a bill, generally is not something that is, I'll say, against what would be the expected things to happen and policy-wise for the university system.
That's correct. The university system has a strong First Amendment policy, and this bill sets
Speaks
forth similar strong First Amendment
Great.
support.
Mr. Fleming.
Thank you, Mr. Chairman. Counselor, you heard the rabbi speak earlier about the incident that happened at UGA and the disruption of their event. Number one, are you familiar with that? And number two, do you know what actions was taken against the students that disrupted that?
I'm not familiar, I don't think, with the February 26th event. I am familiar with maybe a prior one that's on video. And in that circumstance, it actually, to us, highlights the importance of the time, place, and manner reservation process that University of Georgia has in place. So because the Students for Israel, in the circumstance I'm aware of, had reserved a place in advance, they had a security personnel there. The security personnel was able to remove the disruptive students, which is to me a good outcome in that circumstance. If there had not been a reservation policy, which earlier versions of this bill did not require in many circumstances, there would not necessarily have been administrators or security personnel to help separate the disruptors from the people who were expressing pursuant to the policy.
What about the action taken against the students that disrupted the event?
And so I don't know the outcome of. I know they were removed, but I don't know beyond that if there was a hearing. I just don't know.
I would encourage you to look at the video. It's something that Chairman Ligon brought to our attention, that there was actual video of the situation, and it's handled in a very civil manner, and it speaks to having that time, place, and manner language in here that really gets to the heart of what we're trying to accomplish on our campuses.
I guess
there wasn't really any negative discourse on each side. So it was good.
And I guess my question goes to,
Yeah.
however, and I appreciate that. My
Yeah.
question goes to, however, we have heard that actions are not being taken by the university to possibly discipline in some matter students that attempt to keep others from having their free speech rights. Do you know what happened in that situation to the students that disrupted that?
For the one with the video, I don't know if anything happened because it was handled in a very appropriate manner. The one that the gentleman before us referenced, that's the first I've heard of it.
Thank
you.
Yeah. All right. If there's no further questions of these gentlemen, I appreciate your being with us today. We've got several more people. I think from a time standpoint, we'll try and, if we can, keep the comments as brief as possible. It's Stanley Kurtz. Mr. Kurtz, thank you. Come forward, and if you will give us your name and who you represent.
Yes, thank you, Mr. Chairman. My name is Stanley Kurtz. I'm a senior fellow at the Ethics and Public Policy Center in Washington, D.C. I was a co-author of the model legislation on campus free speech that was the basis of the original version of SB 339. Before I launch into my prepared remarks, I just want to very briefly comment on Rabbi Schultz's testimony and some of the issues that have come up since. We've really had 3 incidents now in which there haven't been any consequences for the students. Just removing them, I don't think, is enough to deter similar incidents, and that's why we're seeing an escalation. And I know of incidents very similar by Students for Justice in Palestine against speakers very similar at UT Austin that came close to violence, and we do have a reported assault in a similar incident at the University of Virginia in February of 2018. So these things are escalating, and I think one of the key causes of the escalation is the lack of consequences for the students who disrupt. So you may have policies, but they're not being enforced. All right, Mr. Chairman, no public university system in the United States has the right to exempt itself from the First Amendment. No public university system in the United States has the right to regulate the First Amendment out of existence. The First Amendment protects the liberty of thought and discussion of every citizen of the United States of America, and the leaders of public universities are morally and legally obligated to protect and defend the First Amendment on their campuses, and with it the liberties of their students. None of this is optional. Nonetheless, across the nation and in this great state, universities have disregarded and often directly violated their duty to defend freedom of speech. We know this because universities across the country have repeatedly lost or settled lawsuits challenging their establishment of so-called free speech zones. Yet despite the persistent success of these lawsuits, public universities across the country continue to cabin their students' liberties to tiny, out-of-the-way spots. These so-called free speech zones are the opposite of what they claim to be. They are in fact a strategy for eliminating freedom of speech on the campus as a whole. They are an abuse of the legitimate power of universities to reasonably regulate time, place, and manner of campus expression. And again, we know that these speech zones are an abuse of regulatory power because our courts have repeatedly found it to be so, or there have been favorable settlements very often for the students who bring the suits before it actually goes to court. The First Amendment does not enforce itself, and if campus administrators refuse to protect it, and in fact violate it repeatedly in both action and in policy, then it is the solemn obligation of the legislature to step in and right the wrong. The first obligation of a legislature is to protect the liberties of citizens, nor can we continue to demand that students bring suit against their own schools to secure the liberties those institutions ought to have protected in the first place. No student should have to face the burden of suing their own school. In one case here in Georgia, this was mentioned by Senator Ligon, but I'll repeat the critical facts. A student who filed a First Amendment lawsuit against her school was subject to death threats, was forced to move out of her sorority to a safer location, and was forced to attend class with police protection, all because she refused to drop her suit, a suit she ultimately won. That is not right. And these First Amendment suits continue to be filed here in Georgia. Despite repeated victories or successful settlements in suits against free speech zones and speech codes nationally and in this state, the unconstitutional campus policies that gave rise to these suits continue to proliferate. That is why the legislature must step in. The legislature must act to abolish these pernicious so-called free speech zones. But it has not yet done so. Between 2014 and today, 9 states have abolished so-called free speech zones. The 9th state to do so was Florida, where a measure outlawing speech zones was approved by the legislature just last week and was signed by Governor Scott earlier this week. The simple provisions required to eliminate the pernicious practice of speech zones were not included in SB 339 as it passed the Senate, and they're not in the House substitute either to this point. So it is up to the House to act to include these critical provisions. If you wanted to do this, it would be very easy. You would go to the House substitute at lines 19 through 23. And instead of what it has, it should read, consisting each such institution shall maintain and publish policies consisting of content-neutral, time, place, and manner restrictions on expressive activities using the least restrictive means necessary to achieve a significant institutional interest while leaving open ample other opportunities to engage in expressive conduct for providing use of, etc., etc. This is essentially the formula that's been used in those 9 states, and I would highly recommend it here. Thank you, Mr. Chairman.
Thank you, sir. Appreciate you coming down to be with us today, Mr. Kurtz. If there are no questions of members of the committee, I appreciate you step back. We'll have some others to speak to the committee. I have is Andrew Lawrence, University of Georgia. Mr. Lawrence, please have a seat and introduce yourself and tell us who you represent.
Good afternoon. My name is Andrew Lawrence, and I'm a student at the University of Georgia. Very briefly, I would like to mention 2 specific experiences I've encountered on campus that make me believe that a bill like this is absolutely necessary. For a period of time last semester, I served as the social media chair for Turning Point USA, the largest conservative student organization in the country. This organization prides itself in fostering free speech expression and tackling some of our nation's most controversial economic issues. In this capacity, my interaction with campus reservations was limited. However, following an incident that took place during the latter half of the fall semester, I found the university's current speech policies to be alarming for several reasons. First of all, the fact that students who pay thousands of dollars to attend what is arguably the greatest university in our state and one of the greatest in our country would be required to pay a fee in order for their organization to be represented at the Student Center serves as a financial barrier to free speech. And just as much as requiring student organizations to pay for speech expression on campus serves as a barrier to that speech, the university's current speech zone policy serves as a geographic barrier. Yes, universities should have the ability to regulate time, manner, and place of speech, but free speech zones should be eliminated and students and faculty should be allowed to gather and speak their minds in outdoor areas of campus without onerous hoops to jump through. By doing so, clarity will be added to this environment where currently arbitrary decisions often occur. With that being said, let me give an example of rules being subjectively enforced in regards to registering events with the University of Georgia. As an outwardly conservative student, I feel that there have been several instances in which the university has chosen to ignore enforcement of their own speech policies, particularly when said event is critical of conservatives. In January, I submitted a Freedom of Information Act open records request to a university faculty member who manages these types of requests. In my initial request, I sought records of requests made by student organizations throughout the fall 2017 semester. I was informed that he submitted the request to the reservations office and that I would receive records of said information from that office. After nearly 2 weeks with no response, which I believe to be a violation of the state's record request timeline parameters, I was informed that my request would cost nearly $400 to process, as the information would need to be gathered by staff at a rate of $38 per hour. I was bewildered at the notion that the campus reservations office currently has no database containing reservations of student organizations, and that it would take nearly a week's worth of work to gather. Nonetheless, I amended my request, then only seeking specific information regarding the registration of an event that was held on November 29, 2017 at 1 p.m. on North Campus at the University of Georgia. This event, covered by the student newspaper as a protest, served as a critique of the proposed GOP tax reform bill in Congress at that time. The staff member again responded and informed me that indeed this event was not registered with the university. The University Police Department did not ask the protesters to leave, and the event continued uninterrupted. Public posts on social media show that this was not spontaneous, as it was planned more than 24 hours in advance, and thus shouldn't have qualified as spontaneous campus expression. Based on my experience and the experiences of others, I can imagine a large event expressing politically incorrect views being shut down due to some technicality within the current free speech policies. I don't think that the anti-tax reform protest should have been disbanded, just that the same courtesy be extended to all members of the campus community, regardless of point of view. Now more than ever, students understand the need for dialogue and expression on university campuses. But when an administration infringes upon the rights of students, their practices run contrary to the very purpose of a university. Universities should be canvases of which to paint the masterpiece that is that of the human mind. When we only allow certain groups to express themselves on state-funded university campuses, we run contrary to the most basic function of higher education. Unfortunately, this bill, as currently written, falls short of its goal of defending students and would put unclear laws on the books. For instance, any bill on this topic should more specifically prevent the creation of free speech zones. On line 52, I think it would also be crucial that campuses must have viewpoint-neutral criteria for time, manner, and place restrictions for invited speakers. And finally, I would also like to see legal remedy made available to students if their rights are aggrieved. Thank you.
Thank you, sir. Appreciate you coming to be with us today. Next we have is Kim Harmon with the Southeastern Legal Foundation. Thank you, Ms. Harmon. Have a seat.
Thank you, Chairman. My name is Kimberly Herman, and I'm General Counsel at Southeastern Legal Foundation. Thank you for the privilege of appearing before you today. As many of you are aware, Southeastern Legal Foundation is an Atlanta-based national constitutional public interest law firm founded in 1976. We appear before the U.S. Supreme Court more than 30 times a year in direct litigation and as amicus, specifically including cases with free speech and the First Amendment. Over the past 40 years, we have appeared more than 24 times before the Georgia General Assembly to testify about the constitutional and legal impact of proposed legislation, which is why we are here today at your invitation. For the past 2 years, we have actively engaged in legal research through our national effort, the Student Freedom and Safety Project. At this time, our legal analysis of existing rules, practices, and procedures implemented by public universities to protect free speech, what many refer to as speech codes, concludes that they actually do not protect free speech, but rather violate the First Amendment. According to our analysis, between 1/3 and 1/2 of the universities and colleges we examined maintain either unconstitutional policies or no policies at all. This finding is consistent with U.S. Attorney General Jeff Sessions' 2017 statement that 40% of the universities and colleges across our nation maintain speech codes that substantially infringe on constitutionally protected speech. This is why we need this law. I can tell you that a week does not go by where we do not get a call from a student at a public university or college somewhere in our country explaining that their First Amendment rights have been violated. A number of our public universities and colleges here in Georgia fall in that 40% and in the category of schools where we get students that call us. Some of the schools boast so-called speech zones. They hide behind vague legal language to confine free speech to very limited areas on campus. Some prohibit speech, not because the speech meets the legal definition of discrimination or harassment, but because it might hurt somebody else's feelings. And all of them have created a culture where shout-downs are the new norm. Take, for example, the policies at the University of North Georgia. While there are more than a few constitutional infirmities surrounding their policies, I will point out just a couple here today. First, its chalking policy discriminates against speech based on both its content and the speaker's viewpoint. And second, the school's expressive policy severely limits where its own students may freely express themselves. So much so that no more than 10 students may spontaneously be together to express their thoughts at any given time. Conceivably, the policy could prevent a group of friends from gathering outside for lunch, a touch football game, or even prevent a teacher from holding class outside on a nice day. We know from testimony given before the Senate Higher Education Committee that UNG's policies chill protected speech. While the policies frequently recite that the school only seeks to impose reasonable time, place, and manner restrictions, they restrict so much more. Among various legislative efforts that propose to remedy this constitutional crisis is Georgia Senate Bill 339. It brings the school's policies into compliance with the First Amendment. As introduced, Senate Bill 339 provided important guidance directives to the Georgia Board of Regents and by extension to the public universities and colleges of our state. The bill provided specific and substantive protections to protect free, fair, and open access within reasonable time, place, and manner restrictions to free speech on campuses across our state. It ensured that students know that the schools cannot restrict their speech based on content or viewpoint. The substitute bill removes the majority of these protections and makes the bill ineffective. The bill should establish guidelines that can be employed by Georgia's public universities and colleges to protect individuals on campuses who engage in free speech activities. It also needs to provide for a legal and transparent process by which students and other individuals may seek administrative and ultimately legal redress for perceived violations of First Amendment rights. We as a state owe it to our students to address the problem on our campuses. This means looking at key elements of any First Amendment analysis, objective application, and the process for addressing grievances. When we talk about constitutional rights, especially those protected by the First Amendment, there is no place for discretionary application. SB 339, as introduced, provided an objective response to ensure that all of those attending our state's public colleges and universities may freely express themselves. Without an objective and consistent disciplinary process, the response to the Silencing Act is undoubtedly content-based, speaker-based, and viewpoint-based, all of which are unconstitutional. The procedures provided for in SB 339 should ensure that the response from schools is constitutional, both from a due process standpoint and equal protection standpoint. There was a lot of talk at the Senate committee meeting about how this bill could open up our state's public universities and colleges to lawsuits. However, I'm here to tell you that if we do not do something to protect the First Amendment rights of our students on campuses, the opposite is what's going to happen.
Thank you, ma'am.
Thank you.
Mr. Dryer, you have a question of Ms. Harmon.
Yes, thank you, Mr. Chair. Would this bill that we're looking at have any impact on the cheerleaders at Kennesaw State University that protested during the national anthem?
In what sense? Would it allow them to do that, or would it not allow them to do that?
Would it have any impact on allow them to do that effectively?
Let me think about that one, because I haven't looked at that particular case because they did not contact us. What it would allow them to, because of that situation, I apologize. I don't know if Kennesaw State, how they define the football stadium. Do you know if they defined it as a limited public forum or a designated public forum? Okay. My response would hinge on that, because it depends on how they classify that location. If you're looking at as a traditional public forum, which I don't believe that this bill would actually change that, then it shouldn't change their ability to protest. It shouldn't change a coach's ability to arguably on his own say a prayer to himself before a game, or a player's ability to say a prayer to himself on the game. One of the concerns that was brought up at the Senate committee meeting was that this would turn every location on campuses into a traditional public forum, and it would either allow people to do everything or would allow everyone to protest everything, and there'd be shouting matches, etc. That's not what this bill does. It still gives the schools the ability to regulate First Amendment speech where appropriate. So in other words, if that location is going to be either a designated public forum or a limited public forum, they can do so within the confines of the First Amendment. This bill doesn't change that. So I apologize for
All right, one more
not
question.
as familiar with that case as I, yeah.
Mr. Holcomb.
Thank you, Mr. Chairman. I want to ask about what you said with respect to the spontaneous expressive activity, because you equated that with if students have lunch outside or meet outside, or a teacher could be in trouble. How do you get there? That seems a stretch in terms of what the policy is designed to do.
You get there because the policy is vague. The policy limits spontaneous expression. What is spontaneous expression? In one piece of UNG's policy, it talks about 10 students. In another piece, it talks about 25 students. What is it that they're speaking about? Right? You have a group of people, they might be, cheering for each other as they're playing a touch football game. I know that might seem like an extreme situation, but that's my point. My point, what I'm trying to do here is point out how these policies that the universities have, they're vague, they're overbroad, and they arguably violate the First Amendment. What this bill does is this bill ensures that all of our public universities and colleges in the state will now have policies and procedures in place that are in line with the First Amendment, because I can tell you they do not. The Board of Regents has taken a great step with passing their policy last year, and I applaud them for doing so. But it is a guideline, it is a goal. It does not actually go to every single university's policy and change it to bring it in line with the First Amendment. They're all very different. We have looked at every single policy across the entire state, and I can tell you that, I will not bore you here today, but I'm happy to provide additional information on them. I've got lists and lists of different policies that violate the First Amendment, all in different ways throughout our universities and colleges.
Okay.
And so this
we're short of time.
Yeah,
please.
what this bill brings that together.
All right. Thank you.
Thank you.
Thank you, Ms. Harmon. I want to ask other who's speaking. I know everybody wants to make their feelings and position known, but try and leave your comments to a brief statement about your support or non-support of the bill, and you can explain why you feel that way. Pat Doherty, If you're present, please. Please introduce yourself and who you represent.
Thank you, Mr. Chairman. My name is Pat Doherty. I live just south of Athens and am state president of Eagle Forum of Georgia. I was a student affairs administrator for 36 years on university campuses and just retired from the University of Georgia 3 years ago.
Tell us what Eagle Forum does. What's the policy? What's the purpose of Eagle Forum?
Eagle Forum was started in 1972 by Mrs. Phyllis Schlafly to look at conservative and pro-family issues in every imaginable thing. So,
what's your position about the bill?
my position is that it's very much needed because I, in my job, actually was in charge of the freedom of expression policy at the University of Georgia. And I can tell you, having been on campuses for almost 40 years, they're very, very different from the way they used to be. And a lot of the people who are implementing these free speech policies are actually ideologically aligned with the folks who are doing the protesting and shouting people down. And university presidents do not want to be on the front page of the paper, so it's easier. Free speech can be sort of messy, so sometimes it's just easier to give in to the loud people and not pay attention and not follow up. And as I was talking to the rabbi, I know every person that he has talked to at the University of Georgia who is not responding to him, and they should be responding to him.
Very good. Thank you for coming today. Appreciate your input. Tom Rush. Hey, Mr. Rush.
Thank you, Mr.
Please
Chairman.
Tell us who you represent.
I'm representing Georgia Baptist and an organization called the Great Exchange. Georgia Baptist simply like to say that they support SB 339. I have Reverend Griffin's testimony.
If
you'd like to
submit that to us,
yes, sir. I'll submit that to you.
Go ahead.
And we would appreciate your taking a look at that.
Yes.
I also serve with an
Absolutely.
organization called the Great Exchange. We're a recognized Georgia corporation and approved by the IRS as a ministry. We do not have presence on any college campus, but we work with college campus ministries to assist them and local churches in sharing the gospel on the campus and in their communities. We've had quite a number of events in colleges across the Southeast. We've had conversations with students. We find that college students are very open to having a conversation with us. We're not disruptive. Students that don't want to talk to us, we just wish them a good day and they press on. But we've had over 20,000 conversations with college students on campuses over the last several years. In my personal experience here in Georgia, we have been welcomed on most of our public university campuses. In order for us to come on campus, we have to partner with a campus ministry. They have to get a space in one of these free speech or expressive activity zones, and then we work with those organizations. I'm from Georgia. I'm a graduate with Georgia Tech, so I would take exception as to which is the greatest university in this state.
I think your time's limited now.
I'm also retired. I'm also a retired U.S. military and a veteran of the Afghanistan campaign.
Yes, sir. Well,
when I was serving in Afghanistan, it was my opinion that I was protecting our First Amendment rights along with the others. And I always felt that the entire state of Georgia, in fact, the entire United States, was a free speech zone.
I agree with you.
And I really think it's important for that to do. But our campuses have limited that severely. And I'd like to just give you one example of that.
Would quickly.
We were working at the University of North Georgia. It's already been mentioned that some of their policies are problematic. They have a free speech zone that's a triangle of grass about 300 square feet. The day that we were there, the day that I was there on the campus, we had set up in that grassy area. There's a large sidewalk that goes in front of it. I was standing on the edge of the sidewalk, and a college administrator came out and said, "You can't stand there. You have to be in the grass." So I took one step back into the grass. On the other side of the sidewalk, outside the expressive activity area, was a group representing Habitat for Humanity. They were allowed the freedom to go pretty much wherever in that area that they wanted to go. Now, I certainly champion their right to be there. In fact, I think they're a great organization, and I'm glad they were there. but they were treated differently. And this is an example of how sometimes our policies on the college campuses pick winners and losers. I think these free speech zones and expressive activity areas need to be eliminated, and I would encourage the committee to put that provision back into this bill. But we at the Great Exchange certainly support this bill. We think it's necessary for the free speech rights, First Amendment rights of our students.
Thank you so much. And you have a question for Mr.
Yes.
Fleming, Mr. Rush?
North Georgia College has been mentioned now several times today in this hearing. Do you know who the president is there?
I do not.
Does anybody here know his name? Her name? How long has she been there?
6 years. I'm here on behalf.
Take the message back. There's been some real issues about their policy there.
Thank you.
Thank you. Appreciate you being
Yes, sir.
with us, Mr. Rush. Now, you presented Mike Griffin's comments. He's not here, or?
That's correct.
Okay, thank you. Well, we had him down, but I'm glad to have that. We have next Jane Robbins. Ms. Robbins, you wish to speak?
Well, yes, I did. I want to support the bill as introduced, but in the interest of time, I won't tell you why.
Okay. All right. Well, we're glad you came today. And then we have Virginia Galloway. Ms. Galloway, please come forward. Old friend.
Thank you, Mr. Chairman. I won't take long at all. I'm with Faith and Freedom Coalition. I just want to say that we support the bill. I gave a few reasons the other day. I do want to quickly address this shouting down situation. I've been coming here a long time, and I remember when I used to come here, they'd hand me a little card when I walked in the House gallery, and it said something like, no talking, hissing, booing, clapping, or spitting. You remember that? I've got it at home.
I don't know the spitting part, but
yeah, it was on there. So
was
anyway,
that
I
given
thought it was
just to
kind of
you?
fun. What's
was
that?
given just to you?
No.
Okay, all right. Just wanna make sure.
I might have taken it personally, but I was nicer then. I hadn't been a lobbyist then, you know.
You were nicer when you weren't a lobbyist.
So no, I would just come as a visitor, and they would hand me that. So again, I think that it's just a matter of respecting and having civility,
right.
To not allow anyone. None of you would want to be shouted down. Sometimes I must admit, I might like to shout down what's going on down there on the House floor. And sometimes I might want to clap. I'm not even allowed to do that either, because we have to have respect for the process and respect for the meeting that is going on there. And I think that the schools should have that same respect. Also, before I was with Faith and Freedom Coalition, I was the organizer of the Atlanta Tea Party, one of the organizers of that. And we preemptively met. First of all, we got a permit for our activity. But we also met with the Capitol Police, the Georgia State Patrol, and the Atlanta Police, and I want to commend them because they made sure that we were able to have our free speech, but they also gave people who objected to us an area in which they could protest that was separate from us, but it was close to the Capitol. And I just commend that. I think that that's the way to handle, and I would commend that to the university system, that maybe if somebody really objects to that, we'll give them a spot, but don't let them interfere with other folks' rights.
Good
So
point.
thank you very much for giving me a minute.
You're welcome. Glad to have you. Now, we're going to close off. Does anybody else want to say something briefly to the committee before we close off any further public comment? Yes, sir. Yes. Hold on. Oh, that's right. I've heard you did mention. Excuse me. Craig Goodmark? Goodmark. Excuse me. Please come forward. Have a seat.
Thank you, sir.
My
My name is Craig Goodmark. I'm an education civil rights attorney. Along with my colleague Jerry Weber, I come to speak in support of the bill, but wanted to raise concerns specifically with now new bills 7A and B, which seems to continue the practice of placing additional burdens on the speech of protesters or other invitees during the speech of the invited or the initial invited guests. I'd like to say that this allows, it seems to be, the reading of this new bill allows the university to put their thumb on the scale in one way or the other. And it, as we know, and it doesn't take a scholar to know, that the right to boo is the same as the right to speak out or to cheer. The creation of two sets of rules, it doesn't have a place in our First Amendment's jurisprudence. Justice Scalia actually struck down a similar ordinance that favored some speakers, and he said, St. Paul has no such authority to license one side of a debate to fight freestyle while requiring the other to follow the Marquis de Queensberry's rules. And we believe even in this new version of the bill, which still contains some additional restrictions on invited guests, there is that two sets of rules. And while we support the bill, and we support generally the bill, we do have concerns about that second set of rules for invited guests while
You
speakers
talk
are
about seven. The seven was really, I think, the purpose behind it is to allow someone to protest against who's there speaking. If you differ with their position, you can say I don't believe what you're saying. I don't follow that. But you can't do the point of saying drown them out just to stop it.
I agree with what you're
Recognize
saying.
the opportunity of the other person to speak.
Yes, sir. And I understand what you're saying, but the additional seven, the conjunctive and at the end of seven
And
at
do
line
not-
40, and then the addition of A and B don't interfere and don't prevent professors
Well, that's
from
what it says.
maintaining
Don't
order.
interfere.
Sure, I understand that, but that's
So-
subject to an interpretation that could allow a university to put their thumb on the scale, arguably, sir. And so while
Thank
we
you.
speak in favor of the bill, we do still remain concerned about 7A and B.
Very little legislation we do is perfect. Thank you.
Thank
I
you.
appreciate you coming by today. Yeah, I want to also, we're talking about free speech. I'll say, Ms. Oliver, I personally appreciate what you did. I think the terrible thing that we have this Liberty Plaza out here, whoever the group is, should have the opportunity to book it and use it for that purpose as a demonstration without the oversight of constitutional officers of the state saying yes or no, you can do it, because we agree or disagree with you. And I think that's not one of the university things, but certainly right here at our Capitol, that opportunity of free speech is being depressed. So to you, I say, I commend you. That's my public input. So we'll now close off further public comment. The bill is now in the breast of the committee, and the chair will entertain, first of all, motions.
Do pass.
Have a motion, do pass, and second. And we'll now have discussion, if any. If you will press your light, if you want to comment on the bill or make any further discussion about it. Mr. Fleming.
Mr. Chairman, I just want to thank Senator Ligon for all the hard work I know that he's done on this bill, and I appreciate you bringing it forward.
And I should have invited you, Senator, if you want to make a closing comment about your bill.
No, I just appreciate the committee hearing it. I think enough has been said, and yes, I would appreciate your support.
All right. Thank you so much. Any further public comment? If not, we will have a public comment, any discussion among the committee. If not, is there any proposed amendments? If there are no proposed amendments, we will go to the main question, which is do pass Senate Bill 339 as a committee substitute, LC 298063 TS. All in favor signify by saying aye.
Aye.
Opposed, like sign. The chair is undecided. The chair will call for division. All those in favor, raise your right hand. 1, 2, 3, 4, 5, 6 in favor. All those opposed, raise your right hand. 1, 2, 3, 4. The motion carries 6-4. Thank you, and that will conclude the meeting for today. Appreciate you being with us.